Welcome to the latest episode of Employment Talks, a Lydian podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Hello, everyone, and welcome to the fifth episode of Employment Talks, a Lydian podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Employment Talks is a Lydian podcast. Lydian is a full-service Belgian business law firm with a practical and personalized approach to practicing law. Through a fine blend of transactional law expertise and litigation skills, we deliver straight-to-the-point solutions that add true value. We think client-focused, we act fast, and we speak frankly in a language that you understand. From our offices in Brussels, Antwerp, and Hasselt, our mission is to find solutions through excellent legal insight and strong business instinct. That is how we exceed expectations, deliver consistent results, and forge long-term relationships with industry leaders. Counting 17 lawyers, Lydian's employment, pensions, and benefits team is the largest team you will find in any independent Belgian full-service law firm. We take pride in the size of our team because of the responsiveness it allows us to bring to our clients every day. But even more so, we are proud of the expertise that comes with it. All 17 lawyers, from associate to partner level, advise clients on general employment law topics from the start until the end of the employment relationship, and everything in between, both on an individual and a collective level. Additionally, every lawyer has specific fields of interest, ranging from privacy, health and safety, pensions and benefits, to internal investigations and international employment. My name is Kato Aerts. I'm a partner in the Employment, Pensions and Benefits Department of Lydian, and I'm delighted to be your podcast host. Today, I'm meeting with Hannelore Druwé, associate in our Employment, Pensions and Benefits practice and based in our Brussels office. Hannelore is dedicated to helping businesses successfully navigate their workplace employment issues and focuses both on individual and collective labor law. Welcome, Hannelore. It is great to have you on the podcast.
Thanks, Kato. It's great to be here too.
This fifth episode of our podcast is dedicated to the statutory annual leave. With the Easter holidays behind us and the summer holidays approaching, it is indeed a perfect opportunity to take a look at the current state of play and the legal framework on statutory annual leave in Belgium. Hannelore, can you please explain the basics of holiday rights in Belgium and also give us an update on recent changes?
Of course, Kato. Let us start with a brief introduction regarding the accrual of holiday rights, both in terms of the number of holidays and their compensation. Under Belgian law, employees build up their vacation rights in the year preceding the year in which they can actually take these accrued days annual leave. For instance, the annual leave for 2024 was built up by the employee by having worked in 2023. Per performed or equated month of work in 2023, the employee has built up a certain amount of days annual leave in 2024, this with a maximum of 20 days leave per year in a 5-day work week. When white-collar employees take days of annual leave, they are entitled to their normal salary for these days. This is a so-called single holiday pay. On top of the single holiday pay, employees are also entitled to double holiday pay, which is mostly paid out in May or June. The double holiday pay is calculated based on the number of months the employees have worked, including equated months, during the previous year, and usually equals 92% of their gross monthly salary. Blue-collar employees receive their holiday pay, both single and double, in May or June, and this is paid out via holiday funds. In principle, statutory holidays cannot be carried over to the next calendar year, but should be taken by 31 December of the vacation year. An employee cannot choose to be only paid for the holidays, but to not actually take them. In principle, if an employee has not exercised his holiday rights before the end of the calendar year, these holiday rights will be lost. The previous rules only apply to statutory holidays. For extra-legal holidays, other rules may be implemented within the company, for example, laid down in the work rules.
Thank you, Hannelore. I heard you say, in principle, it is not possible to carry over statutory annual leave to the next calendar year. Do I understand correctly then that there are certain exceptions to this principle?
Indeed, the Belgian legislation related to annual leave was recently amended in order to be in accordance with the so-called European Working Time Directive of the 4th of November 2003. Under this directive, member states of the EU must take the necessary measures to ensure that all employees have at least 4 weeks of paid annual leave. Since in certain situations it is impossible for employees to take their holidays before the end of the year, and these holidays would be lost under Belgian law, the European Commission threatened infringement proceedings against the Belgian state for some time. Belgium therefore had to amend its legislation. As of 2024, an employee who at the end of the vacation year is unable to take his vacation days due to certain work interruptions to carry over these vacation days up to 24 months after the end of the vacation year. For example, untaken holidays during the holiday year 2024 will in certain cases still be able to be taken until 31 December 2026. As a result of such carried over holidays in the following years, in our example 2025 and 2026, its statutory holiday may exceed 4 weeks. In the circumstances listed exhaustively in the Belgian legislation, the transfer of statutory holidays to the next year is even mandatory. It concerns suspensions of the employment agreement due to a work accident or occupational disease, an ordinary accident or illness, maternity or paternity leave, prophylactic leave, birth or adoption leave, foster care leave, or foster parent leave. The possibility of carrying over holidays to subsequent years is only possible if it was impossible to take the holiday in the correct year. Both the employer and the employee must make efforts to take the holidays within the year. How the impossibility will be assessed, for instance in case law, remains to be seen. Sometimes this will of course be obvious. If an employee suddenly falls sick as from June 2024 and this until the end of the year, it seems logical to us that the employee was unable to take up all their holidays in 2024 and that they have a right to carry them over to the next year. It could, however, be different if an employee still has 10 outstanding holidays at the end of December 2024, has not planned any holiday days, even though his employer has reminded him of the outstanding balance, and then suddenly on 17 December 2024, which is 10 working days before the end of the year, he becomes unfit for work until the end of the year, making it impossible for them to take up their outstanding 10 holidays. Here, an employer could argue that the employee was not actually in the impossibility of taking his holiday in the correct year, and that the holidays are simply lost.
So does carrying over the statutory holidays to the following calendar year mean that the holiday pay should then also be paid during the following calendar year?
No. The holiday pay relating to the vacation days carried over to the next 24 months must be paid by the employer no later than 31 December of the original vacation year. In other words, it is an advance payment of the vacation days carried forward. At the time the employee actually takes one or more of their transferred holidays, these days will always be unpaid. Please note that the above only concerns holidays that were not taken as a result of an impossibility due to the limited circumstances mentioned in the legislation. Holidays that were not taken for other reasons and where the reason does not lie with the employer, for example, because the employee does not plan their vacation despite being reminded by the employer, are irretrievably lost and should not be paid out.
Okay, thank you for this explanation. Are there also specific rules if a period of annual leave coincides with a period of incapacity for work?
Indeed, yes. Since the 1st of January 2024, this is indeed the case. Before, the rule of the first grant of suspension of the employment agreement applied. This meant that if the employment agreement was suspended due to statutory annual leave, illness could no longer adjust this ground for suspension. It would remain a period of annual leave. The employee was simply out of luck and the holiday would be lost. On the other hand, a planned holiday period could be postponed if the employment agreement was already suspended due to illness before the planned holiday period started. This rule could no longer be applied as it was not in accordance with the European Working Time Directive and the case law of the European Court of Justice. After all, the court considers that sick days are meant for healing, while holidays serve for rest and relaxation. Under European law, 4 weeks of rest and relaxation indeed have to be guaranteed. Therefore, the Belgian legislation was amended. As of 2024, sick days will no longer be charged to the annual holiday in case of illness during the holiday period. Consequently, these vacation days can be converted into sick days. In principle, the employee will be able to receive guaranteed salary for those sick days as long as they meet the conditions and formalities for this. To apply the above conversion, the employee must undertake certain steps. Firstly, the employee is required to immediately notify the employer of their incapacity for work and of their residence address if they are not at their home address, for instance, if they are in a foreign country. Additionally, the employee must submit a medical certificate to the employer within 2 working days from the day of incapacity or the day of receipt of the employer's request thereto, unless a different deadline is set by a collective bargaining agreement or by the work rules. In cases of force majeure, the employee must submit the medical certificate within a reasonable time. The medical certificate should mention the incapacity for work, the probable duration of the incapacity, and whether or not the employee is permitted to move to another place for the purpose of medical control. A specific model of medical certificate is established for incapacity of work occurring during a period of annual leave. However, the use of this specific model is optional. The medical certificate must always be presented in case of incapacity for work during annual leave. The existing exception for 3 times per calendar year for a first day of disability is introduced in the Belgian legal system in 2023 cannot be applied in this context. It seems appropriate to us to specify in the work rules that a medical certificate should be drawn up in, for instance, Dutch, French, German, or English, or at least translated to one of these languages. This avoids an employee being on holiday in, say, Turkey, and submitting a medical certificate in Turkish, which is presumably illegible to the employer. Lastly, no later than its time of submission of the medical certificate, the employee must expressly notify the employer that they wish to carry over and take the vacation days coinciding with the incapacity for work at a later date. An employee is obviously not required to notify their employer that they are ill during their holidays if they choose not to have their holidays converted into sick days. It is indeed not mandatory to do so. Please also note that a conversion of holidays into sick days does not imply that the agreed holiday period is automatically extended by the amount of days converted into sick days. In line with the general rules on the planning of vacation days within the company, the employer and the employee have to agree on when the converted holidays can be taken at a later time. If an employee has agreed to a holiday period running from the 1st to the 14th of July 2024, and the employee falls ill from the 8th until the 12th of July, the employee can convert 5 holidays into sick days if they comply with the necessary formalities as mentioned before. The 5 holidays can still be taken by the employee at a later date. However, this does not mean that the employee is entitled to an extension of their holiday period until the 19th of July 2024. They need to return to work on the 15th of July, unless it was otherwise agreed with the employer.
Thank you, Hannelore. I think this is very interesting for our audience to know with the upcoming holidays. Can you also give us some information on what happens to accrued holidays and holiday pay if the employee leaves employment during the holiday year?
Certainly. In this context, the distinction should be made between blue-collar and white-collar workers. In the case of blue-collar workers, the accrual of holiday entitlements and the calculation and payment of holiday pay are regulated by the National Office for Annual Leave and by the Holiday Fund to which the worker is affiliated. Holiday pay is paid between the 2nd of May and the 30th of June of the holiday year. A change of employer does not affect this. For white-collar employees, the former employer is obliged to hand over 2 holiday certificates, one for the year preceding that in which the employment agreement ends, and one for the year in which the agreement actually ends. These certificates show how many holidays the white-collar employee has accrued with his ex-employer and how much holiday pay must be paid to the employee. White-collar employees also receive departure holiday pay from their employer when they leave employment in the course of a calendar year. Since holidays are accrued on the basis of services rendered during the holiday service year, it is the employer with whom these services were rendered that is responsible for paying the corresponding holiday pay. The employee's new employer will also pay holiday pay, but will be allowed to deduct the already received departure holiday pay from it. After all, the employee should not be paid twice for the same holiday. Since 2024, a new method of settling the single departure holiday pay applies. Whereas previously the settlement was done at one fixed point in the year, it can now be done in 2 steps. At the time a new employee takes a holiday for which the entitlement was accrued with a previous employer, the new employer has to deduct 90% of the gross daily salary of the employee. In other words, the white-collar employee will receive only 10% of their gross daily salary for each holiday taken. In December or earlier, if the employee leaves employment, further corrections to the deduction that already happened during the holiday year should be made. What I said before is, of course, fairly technical. Fortunately, in principle, the payroll agency will be able to help with such administrative matters.
Thank you. Maybe to conclude, it would be useful to briefly remind employers of what they should keep in mind for the upcoming vacation period.
Of course, as an employer, you are required to grant statutory holidays, even if the employee does not explicitly request them himself. If you fail to do so, you may even be criminally sanctioned. It is therefore advisable to monitor the number of remaining holidays per employee throughout the year, and in particular in anticipation of the upcoming summer months, where most employees usually take some extended leave. An overview of the taken holidays can then be sent to the employees concerned in September or October, stating they must take these holidays before 31 December of the current year. A reminder of outstanding balance could once again be sent in December. In case of a social inspection, you can then clearly demonstrate that you have informed your employee that you have encouraged them to take up their statutory holidays, and that it was therefore beyond your control. This should probably be able to prevent any criminal conviction.
Duly noted. Thank you, Hannelore, for sharing this clear overview of the current state of the law. Also, many thanks for taking the time to record this episode of Employment Talks with me. I enjoyed it a lot, and I hope you did too.
Of course, the pleasure was all mine.
The last words go out to everyone who tuned in for this episode of Employment Talks. I hope the content of this episode was as entertaining and interesting for you as it was for me. If you have any questions in relation to the topic we brought to you today, of course, feel free to reach out to Hannelore or to myself. If you do not have our contact details yet, make sure to visit us at our website, lydian.be, or simply reach out through LinkedIn. This was Employment Talks, a Lydian podcast. If you like this episode, please make sure to subscribe to this podcast wherever you listen to your podcasts, and feel free to leave a comment or share it with people you think may be interested too. We look forward to hearing from you, and we would love to welcome you again in 2 weeks for our next episode. This was Employment Talks, a Lydian podcast. If you liked this episode, please make sure to subscribe to this podcast wherever you listen to your podcasts, and feel free to leave a comment or share it with people you think may be interested too. We look forward to hearing from you, and we would love to welcome you again in 2 weeks for our next episode.